Oklahoma City, and streaming audio at KTLV1220.com.
Friends, hello and welcome to another episode of The Legal Breakdown. This is Jason Sansone, and we are pleased to be live with you on another wonderful Oklahoma Wednesday. As always, this show airs live on KTLV 1220 AM. That is our host on terrestrial radio. You can also listen on the TuneIn Radio app, or you can watch us live on Facebook.com through our Facebook Live feed. You can find that on the Sansone Howell Facebook page. If you need assistance in finding that link, you can go to SANSONEHOWELL.com, SansoneHowell.com, where we have links to all of these various pages. Or if you're not able to listen to the show when it airs live from 5 to 5:30 on Wednesdays, you can always listen to former broadcasts on podcast. Those are available on Apple, iTunes, the Google Play directory, or Spotify, and the video is uploaded to YouTube.com every week. Again, those links are available on our webpage. We take questions live on the air. If you have questions, you can post those through the social media on Facebook, or you can always call in at 405-347-7238, and I'll take your call live on the air and answer any legal questions you have, whether it's related to that day's topic or not. We're happy to take your calls. Friends, today we're going to dig in and talk about debt collection, and most specifically, how to defend, how to protect yourself against attempts to collect a debt against you. So we need to start out with breaking down that broadly there are two ways to collect a debt against an individual. There's what's called non-judicial or judicial. Well, so what does that mean? Pretty straightforward. I can try to collect a debt against you not using a court, not using any type of judicial power, or I may take action against you and try to collect a debt using a court system through a lawsuit, an attempt to collect. That would be a judicial method of collection. So what you need to understand is the techniques you're going to use or the defenses available to you are going to be based upon which one of those methods, possibly both, are being utilized by the debt collector, the person who's trying to seek monies against you, whether that was a lender, whether that's someone you've wronged, whatever it might be. Judicial or non-judicial is the approach you're going to take. Now, we're overall in this conversation sort of working around the assumption that we're talking about some type of consumer debt, that we're talking about a medical bill, a credit card, a loan, whether that's a small local loan, payday loan, maybe it's a large bank loan, could be secured, unsecured, line of credit, all these different things. But overall, I am making the assumption, it's important we identify what assumptions we're making. I'm making the assumption when we make this conversation today that we're speaking to consumer debt. However, it doesn't have to be consumer debt. It could be non-consumer debt, meaning some type of business loan, not related to personal finances or consumer actions, or it may not even be a traditional, trade line type of debt. Like I touched on, it's also possible that we simply have actions related to various contract disputes. We could have disputes between landlords and their tenants. You could have actions where, personal injury, but on a small scale. I get into a bar fight with someone, I punch them. How are they going to try to collect against me? So this conversation isn't exclusively to consumer debt, but we are working over that general concept. So keep that in mind as we go forward. The person that's collecting, whether that's an individual, whether that's a law firm, whether that's some type of collection agency, they're going to be the ones determining who, what these actions are, whether we go judicial, non-judicial, what steps are taken. And that's going to be usually in communication with their tentative client, the person who actually holds the cards. In other words, who's got the money that's trying to be recovered. If someone's collecting the debt themselves, in trade lingo, we call that prime. So if you have a credit card with Discover, and I'm just using them as an example, and Discover's the one trying to collect against you directly, that debt is still prime. Hasn't been sold off, isn't to a third-party debt buyer, or it's not being worked by a third-party collection agency. So if I use that expression throughout the episode, you'll understand that I mean the original creditor, the original lender. Who is working it, though, is important, and that's going to come into play in a bit when we talk about some of the federal protections you have. But so, you're going to want to know who it is that's collecting against you, what steps they're taking, judicial, non-judicial. There are a lot of times, and I say this out of the gates to be aware, that non-judicial is all that is ever done. Judicial never even occurs. There are a lot of types of debt that it doesn't make sense to sue on. I'll give you an example. They're called micro balances. Anything that's under $100. Maybe it's a medical debt, maybe it's not. Historical example was the Hollywood Video portfolio. Hollywood Video went out of business. They had, a lot of unreturned movies or movies that were damaged, whatever it might be. Some of those then they tried to collect on. It was actually part of a big Chapter 11 bankruptcy proceeding, but they never took action to sue on that. Millions and millions of dollars total. But individually, it doesn't make sense to sue someone on $20, $50, $75. So then the only steps they would take would be non-judicial. So you're going to keep that in mind, the size of the balance, what type of debt it is. Keep that in mind when you're thinking about what it is that a creditor would do, because also they may or may not threaten things that they're never going to do. Now, they're not supposed to. It's not usually legal to threaten collection activity that you have no intention of taking or you never take. But, hey, these things happen. So you as the consumer, you as the individual that, is listening to this show, wants to be informed of what rights you have, what rights they have, and then know, how much of this is a game of poker. Are they bluffing? Will they really take a certain collection activity or not? So let's now jump into non-judicial. Non-judicial collection steps are going to be calling you, lettering you. They're going to be credit reporting, but they're going to be steps that are taken without the power of a court to try to get you to pay a bill. And I say try, and I enunciate that very strongly for those that can't see my facial expression that are listening to the show, because a non-judicial can never make you pay. You got to remember that. They can't make you pay. They can take steps that incentivize you to pay. You may want to pay for various reasons like credit reporting, but they can't make you. The only time someone has the power to take your money, to reach in your pocket, take food off the table, is when they've obtained order of a court, when they've been given that permission by someone through a judgment, through a lien. But before that step, if they're not using judicial collection methods, just remember that it's all bark, no bite, or at least the bite is only as powerful as you choose to let it be. So yes, they might be able to ding your credit, but we'll talk about things you can do to protect that. Yes, they might have the right to call you up to a point, but whether or not that intimidates you, whether or not that person can scare you, you are in control. You give them the power or you don't give them the power. And I want to really stress that because so often when we meet with bankruptcy clients, although they may be a perfect candidate for bankruptcy and we ultimately file a bankruptcy for them, one of the things that's driving their bankruptcy, for lack of better words, is fear. It's not knowing the legal protections you already have. And the more educated you can be on a subject, the more that should put your mind at ease because you know what a creditor really can do or, inversely, can't do. So that's what we're doing. We're educating you. We're letting you know where the bark really is and where the bite really is, because don't let fear-mongering take hard-earned money out of your pocket. So some of the protections you're going to have in non-judicial collection. First would be state law protections. So if you don't live in the state of Oklahoma, you may have protections. How good or bad they are depends on where you live. Some states, such as California or New York, have very in-depth consumer protection acts at a state level. Unfortunately, for those that, like me, are in Oklahoma, you got virtually nothing. There's not really a Consumer Protection Act with regards to non-judicial collection type activity unless you're already subjected to the federal rules. So 3 big federal laws that you need to know about if someone is trying to collect against you. Number one is the Fair Debt Collection Practices Act. That is going to be applicable to these third-party debt collectors. So if a law firm is subject to the FDCPA, they're going to have to follow those rules. If a debt collector is subject to the FDCPA, they're going to have to follow those rules. But at the beginning of the episode, we broke down and we described first-party collectors or prime lenders, prime collectors. They're typically not subject to FDCPA. So if you have a loan from a small payday company and they're trying to collect against you. So in Oklahoma, we've got several on my street here. We've got Red River Credit, you've got BNF Financing, BNR, Cash Advance, Cashland, all these places. Okay. If they call you and they violate what is the FDCPA, you can't sue them under FDCPA. They're probably not subject to FDCPA. So keep that in mind. But if they are subject to FDCPA, you should familiarize yourself with that. There's some tricks there that you can use to protect you. Number one, they have to validate the debt. They've got to send you notice, and they have to give you time to respond. You need to do it within 30 days to keep things simple for this episode. But you're going to tell them that you want validation of the debt. That's a step. If you have an attorney, you can tell them that you only want them to communicate through your attorney. You give them their contact information. They no longer can call you or letter you. They have to work through your counsel. So that's another step to diminish their collection power. You can tell them you only want to communicate in writing and that you will communicate with them in writing. They can no longer call you. So some of these are some steps you can take. Moving forward to the TCPA, Telephone Communication Practices Act. Unless you have given explicit written permission, basically by putting a phone number in a contract or indicating that they've got the right to call it, there's restrictions on how you can call cell phones as opposed to landlines, whether you can robo-dial, can they be auto-dialed. That's all going to be applicable to big house debt collection companies. So if they're manual dialing, hey, they're still going to call your cell phone. So local payday lender, they pick up the phone, they dial 837-653-609. Okay, they get a hold of you. That's legal. But if they're using a system that robo-dials and runs through millions of numbers, they very likely cannot robo-dial a cell phone. So keep that in mind. You might have some protections there. And the Fair Credit Reporting Act, FCRA. That you can use to dispute if someone's credit reporting something and you don't think it should be on your credit or you don't think it's accurate. There's 3 credit reporting agencies: Experian, TransUnion, Equifax. They all have publicly available information on how you can do disputes. Disputes are free. You can do them either online or paper form. Some of the different ones allow you to fax in disputes. But that is another tool in your toolkit to fight debt or to dispute debt that you can use to get things cleaned up. Debt that's derogatory or credit reporting items that's derogatory can only stay on your report for 7 years from the date of last activity. So if you have a credit card, it gets charged off, you don't make any more payments, it sits there delinquent, it's only going to stay for 7 years. Positive credit reporting history is 10, so keep in mind that if you see something on your credit report and you wonder why it hasn't fallen off and it's been 8 years, well, if it shows good credit reporting history and it's not derogatory, it's going to stay longer. That's a positive for you, in fact. That's why it is. But so, that is a few things. And we were about halfway through our show. We're 16 minutes in. So I don't want to spend too much longer on non-judicial other than to be aware of you've got some protections, not a lot at the state level. But if someone's calling you, if they're lettering you, if they're bugging you, the power you give them really is up to you. And then whether or not you care that your credit report's been dinged is sort of a choice. And I don't mean that to be ugly, but we all know that we all have different credit reports. How it looks is going to be a fact of, what your life has entailed for the last few years prior. If you're a person that has stable employment, you don't have any other debt, you don't have credit card bills, you pay your bills on time, you got an 800 credit score, and then you get hit with this bill and it dings your credit 60 points, you're obviously going to be much more inclined to want to call up and pay. And so that's where sometimes microbalancing, or what we call warehousing, where you just throw things on credit and wait for someone to call, is much more effective against those kinds of people. On the other hand, if you have a 500 credit score and unfortunately you've had some tough times. You're the type of person who's in need of a fresh start and probably a good candidate for bankruptcy. Credit reporting against you is far less effective than if I throw a $60 balance on your credit report, but you already had 2 vehicle repossessions. You're not going to call me up and instantly want to pay that $50 balance. So it all depends on the individual, the effectiveness, of the strategies you take. Now, judicial debt collection, meaning through the power of the courts. And I want to pause for a second. We should have probably touched on this at the very beginning of the episode, but so we're going to touch on it now. Every debt, period, every debt is going to end up resolved in one of a couple various ways. It's either going to be paid in full, it's going to be settled, you're going to bankrupt out of it, or for one reason or another, you're going to prevail in never having to pay on it at all. But if you think about it, that's the only options. You either don't pay anything, you pay something, you pay all of it, or you bankrupt out of it. The goal of this show is to let you know these options, because if you don't think you owe it, or even if you owe it, but you're not in a position where you can pay it in full, then ideally, you're going to end up paying only part of it or none of it and don't have to file bankruptcy. The whole reason of telling you this, my listening audience, is to give you these tools to protect yourself, to settle a debt, to make it so that we can reduce how much we have to pay. So now, judicial debt collection. Judicial debt collection is always going to start the same way. You're going to be served with a summons and a petition. You're going to be served a lawsuit. From there, the defenses you take will vary. But we like judicial because it's clear, because it's clean, because we know what we're dealing with. If you're dealing with a shady lender, or maybe even a questionable scam, it's good to tell them to put their cards on the table, shut up or put up. Sue me. We'll deal with this in court. And I often tell clients to take that approach. I've personally taken that approach. I'm not going to litigate over the phone. So if someone calls you and they say you owe them money, and you're not sure that's real, get it in writing. Or, hey, we have a lawsuit against you. Well, I haven't seen it yet, so let's wait to see it. Those are the types of things that I want to become judicial debt collection, because I wonder if they're even real debt collection. So I say that because now we're going to talk about some of our defenses. You're served. It's legitimate. You've got this lawsuit in your hand. First thing to look at is, has it blown what's called the statute of limitations? A statute of limitations is a legal time barrier, a time bar, on how long someone has to bring a cause of action, after which point you can no longer bring it. So it's only about up till when you file that lawsuit. When the action arose can get touchy depending on the type of statute of limitations we're talking about. But we're just talking here about contracts, so written or oral agreements to pay money. We're talking consumer debt. In the state of Oklahoma, the statute of limitations is 3 years on an oral agreement and 5 years on a written agreement. So we're just going to work on 5 years because virtually anything you do is probably in writing. You go to the hospital, you agree to get services with them, 5-year statute of limitations. You get a credit card, you get a loan, you buy a car, 5-year statute of limitations. Now that 5 years starts to run from the breach, from the default date. So whenever you last missed a payment, whenever you voluntarily surrendered a car, whenever they repossessed it, that's when the 5 years starts, not necessarily when we started the contract. So if you buy a car and then it's a 5-year note, but 3 years in you return the car, and 2 years later they sue you, you can't say, oh, it's been 5 years since I bought that car. No, the statute of limitations didn't run yet. But be looking at these things, because it isn't, people screw this up. It's common for lenders to inadvertently blow a statute of limitations and be over that. Now, in a world with computers, where we've got digitized information, it's getting a lot more common where, people are on the ball, but not always, especially if it's been bought and sold multiple times. Where you have third-party debt buyers, their debt information is often bad. The amount of docs they have aren't great. And these are the types of cases we're going to want to challenge. You're going to want to challenge to make them prove it up. And if anything, what it can do is it can give you leverage for a better settlement. But so be aware of a statute of limitations. Also, you need to be aware out of the gates that that is a use it or lose it defense. If you don't raise it initially, you're waiving it, meaning you can't come back later and say, oh, you guys were out of time. Sorry, Charlie. You need to make sure you're aware of these things up front. So once you are served with a lawsuit for collection, you're going to do one of three things. You're either going to be filing a motion, like a motion to dismiss, or you're going to file an entry of appearance and reservation of time, or you're going to file an answer. Depending on what you do is a little bit beyond the scope of time for this episode. You might want to speak to counsel, but be aware that if you file a motion to dismiss, you then don't have to file an answer yet, because you're going to wait to hear from the court, and then they're going to order you to file an answer if you don't prevail on all counts of that motion to dismiss. If you file an entry appearance and reservation of time, you're saying I want 20 more days, and this is Oklahoma law, to answer. So you get served, you've got 20 days to respond, you file an entry, you get 20 more days. But at the end of that, you got to file an answer. If you file an entry appearance and reservation of time, you cannot file a motion to dismiss. You waive the protections there. You should have done that instead of filing the entry appearance and a reservation of time. Or you just file the answer out of the gates. An answer is basically a response to the allegations in the initial petition. So you're saying, I deny, or we have lack information and knowledge to possibly answer the different things stated in that petition. After that occurs, though, you're going to move into discovery. It's important, though, regardless of which one of those three things you do, that you do one of them and that you do it timely. Because if you don't, the creditor can just take a default judgment. If you're out of time, if you haven't responded, they're going to get what they have asked for in the complaint. So I sue you, I say you owe me $1,000, I give you 20 days to respond. On day 25, I go down to the courthouse and I can take default judgment against you, and I get an order, I get a judgment that says you owe me $1,000 because you didn't do anything in the time that you needed to. And that is very important because, unfortunately, the majority of cases are defaults. Creditors chase the low-hanging fruit. When you respond, they're much less likely to fight you because they're going to go for the person that doesn't want to fight you. They're going to go for the person that didn't bother to do anything. You should always enter an appearance, file a motion, or file an answer, if no other reason than to leverage your ability to settle the case for less than they claim you owe. Because otherwise they're just going to start to garnish you. Because a judgment is a piece of paper that says you owe them money. Then the law provides ways in which you can satisfy a judgment. In other words, collect on it, get paid. The most common is a recurring wage garnishment. In Oklahoma, the limit is 25% of your gross wages. For friends that are listening in Texas, good news, your state constitution doesn't permit recurring wage garnishments, so you don't have to worry about that. But in Oklahoma, we do. Of course, that doesn't change that in virtually all states. You could put a lien against real property. You could levy bank accounts and continually hit and sweep those. So there's other things you can do other than just recurring wage garnishments. But the most common is a recurring wage garnishment. So I sue you, I win, and now your employer has to start giving me a quarter of your check every time you're paid. And that's off the top. That's gross. You're still paying taxes on the money you earned, even though I'm getting sent a big chunk of it, which means that the amount of your check you're actually going to get is even smaller than you realize. It's not 25% of the net, it's 25% of the gross. So we protected ourselves from default judgment. We didn't allow that to occur. We filed either an entry of appearance or reservation of time, or we filed an answer, or we filed a motion to dismiss. In all of those, we thought about our affirmative defenses. What are the things that we are going to raise that are problematic? Is it fraud? Is it set off? Is it a statute of limitations? There's different things. And again, affirmative defenses are things that are either raised out of the gates or you potentially waived it. You don't get to raise it later. What are all the affirmative defenses that are enumerated or allowed in the state of Oklahoma? We only got 3 minutes left, so that is beyond the scope of this conversation today. I can't go into all these things, but you should be aware that they're there, and you need to be aware that if you don't use it, you lose it. Okay. Now we're in discovery. Now, for those that have watched the show before, some of this information is going to be similar. Some of this information may feel redundant or overlapping, and that's okay. It means that we're starting to learn some of these different issues, and we can protect ourselves, we can defend ourselves. Discovery is the middle area to a lawsuit. It's the time period when sides have to exchange information to learn about the case to try to bring the truth to light. With discovery, you're going to have to send and answer what are known as requests for admission or requests for interrogatories. Answer questions, ask questions. You might have depositions. You might have to take depositions. You might have to give a deposition. We're going to have requests for production to exchange information. In a consumer case like this, though, it'd be pretty normal to ask for billing statements, bank statements, original contract information, signs saying that, hey, I agreed to what you claim I agreed to. I incurred the debt you claim I incurred. They're going to want you to admit, yes, you signed it, yes, you borrowed the money. So that's important because obviously if this is a case where we don't have those types of things in dispute, meaning I sue you for $1,000 and you're saying, whoa, I never even owed you that kind of money. Well, that's a dispute. On the other hand, I'm Discover Bank. You have a credit card, has a $1,000 credit line. You max it out to $1,000. You don't pay it, and I sue you for $1,000. You know it. You borrowed the money. You owe the money. You admit you do. It's not going to be a long case, let's be honest. If they serve you with requests for admission and interrogatories, and you say, yes, I agree to the contract. Yes, I took the line of credit, I borrowed the money, and I used it. No, I didn't repay it. So what defenses do you have left? That is then leading us into the next thing we're going to talk about. At some point during discovery, or near the conclusion of it, the case is going to either have a motion for summary judgment, or it's going to ultimately end up in trial. Odds are you're not going to go to trial. Very few cases end up going to trial, whether that's a jury trial or a bench trial. Either way, there's no point because what a motion for summary judgment is, and we talked about this in depth when we had our episode where we talked about foreclosures, both judicial and non-judicial foreclosure. It's saying that when the judge looks at the case and they look at the facts most favorable to you, basically the non-moving party, there's still no issue of fact left, and the court should rule on the case right there without continuing. So if you get into discovery and you admit that you owe the money, they're going to file a motion for summary judgment. They're going to file an MSJ, and they're going to attach all those records, and they're going to say they've admitted they owe it. There's no controversy. This needs to be over, and we need to win. Obviously, our goal, especially as part of this episode, is to not let things go to judgment, to not end up at an MSJ or a default judgment or even a final judgment on the merits from trial. You need to resolve this before then. So, revisiting, we said that every case ends with either payment in full, settlement, no payment, or bankruptcy. Maybe the whole goal was to buy time. Maybe you ultimately planned on filing a bankruptcy, and you can use these steps now to protect yourself from a garnishment or from bank levies while you strategize and get into a position to be better suited to file either a Chapter 7 or a Chapter 13. Maybe you are a potential bankruptcy client. But if you're not contemplating bankruptcy, and the goal here isn't just to buy time and drag out cases and delay your creditors, then you need to be looking for an exit plan. You need to be thinking, okay, the whole goal here was just to settle. The goal was 50 cents on the dollar, 60 cents on the dollar, a payment plan that's more amenable to my income. Those are the types of things you're going to be looking at, because if you aren't thinking forward as to how you're going to dispose of this judicial collection, you're going to run out of time eventually. The honest answer is you're not likely going to just outright win. It's not going to be a situation where they sue you, you prove you don't owe the money at all, you walk out of court, no judgment, hooray, we are victorious. It's possible, but it's not necessarily the message that we're speaking to today as part of this program, because it's not a very realistic situation. So be thinking about where you go. So it's now time for us to begin wrap up. We covered a lot of good information. I hope that you learned a lot today. Someone tries to collect money from you, one of two ways, judicial or non-judicial. With either of those options, be thinking about your defenses. Maybe that's under the FTCPA, TCPA, or Fair Credit Reporting Act, FCRA. If it's judicial, remember, do not let it go to default judgment. Always, always, always try to collect, or try to keep them from collecting and make sure you file an answer or something in that case. Friends, I am Jason Sansone. This has been another episode of The Legal Breakdown. Tune in next week, every Wednesday, 5 to 5:30. We look forward to seeing you then. Have a wonderful evening.